Kia ora, my name is Rachel, and I work as a community educator for Auckland Disability Law, or ADL. So ADL is a community law centre that specifically helps deaf and disabled people with their disability-related legal issues. And it's important to say that although our name is Auckland Disability Law, we can work with deaf and disabled people who live anywhere in Aotearoa, New Zealand. We also do legal education seminars for the community like I'm doing today, and we get involved in some law reform work. So what we're going to talk about today is supported decision-making and how this intersects with various legal instruments that empower other people to make decisions for you, such as enduring powers of attorney and orders under the Protection of Personal and Property Rights Act. Just note also that today's session is about information only. It's not legal advice. When we get into the question and answer session later, I won't be able to answer questions about individual situations or cases, but I will direct you towards places that you can go if you do need help with a specific situation at the end of this presentation. So there are definitely people who can help in individual situations, but this is not the forum for doing that. So today what we're going to do is first we're going to talk about supported decision-making, what it is, the legal frameworks that empower people to use supported decision-making and how it can work in practice. And then we will look at the options that are available under the law when more than just supported decision-making is necessary. So that includes enduring powers of attorney and orders under the Protection of Personal and Property Rights Act. So, what is supported decision-making? Well, everyone has the right to make decisions about their lives, and also everyone sometimes needs support to make decisions. For example, you might research what the different options are or talk to a friend about your decision. Sometimes disabled people need extra support to make a decision, and this is referred to as supported decision-making. So supported decision-making assists disabled people to have choice and control over their lives, whilst ensuring that they have the support they need to exercise that choice and control. So supported decision-making is a human right. Article 12 of the United Nations Convention on the Rights of Persons with Disabilities, which New Zealand is a signatory to, affirms the right to supported decision-making, and the New Zealand Disability Strategy also upholds the right to use supported decision-making. Finally, that act I've mentioned a couple of times, the Protection of Personal and Property Rights Act, also sets out the legal rules for situations where another person is empowered to make decisions for a disabled person, which is known as substitute decision-making. But even that act still requires that the person who has the power to make the decision takes the disabled person's preferences into account. Unfortunately, even though supported decision-making is a human right, sometimes it can be difficult to do in practice. For example, at ADL, we quite often get calls from people telling us that an agency such as WINS or the bank has told them that the disabled person needs to have a power of attorney in place before the agency can speak with the person and their supporters. Now, it's important to note that agencies that say this are incorrect. Everyone has the right to practice supported decision-making if they want to. However, sometimes you have to stand up for your right to practice supported decision-making. So what we're going to do now is look at some of the elements of supported decision-making, and then we'll go through an example to see how it can work in practice and how disabled people and their supporters can advocate for their right to practice supported decision-making. So when you're practicing supported decision-making, the first thing to work out is what decision actually needs to be made. It might be a small decision, such as what to eat for breakfast or what TV show you want to watch, or it might be a bigger and more complicated decision, like deciding to move out of home or deciding whether to take a certain medication. You might also have more or less time to make the decision, so it might be a decision that has to be made right now, or it might be a decision that you can spend some time thinking about and take a couple of days or even weeks to make the decision. So identifying what decision needs to be made is important because it helps you to work out how much support is needed. For example, you might not need any support to decide what TV show to watch, but for a bigger decision like moving out of home, you'd likely need more support. When a decision is big, it can also be helpful to think about whether it can be broken down into several smaller decisions. You might then be able to make some or all of those smaller decisions with support. For example, a big decision about managing your money could be broken down into smaller decisions like what bank to use, what type of account to open, whether to have an EFTPOS card or not, whether you want anyone to help you manage your money, and if you do, who you want those support people to be, and so on and so forth. Now, there are several tools you can use to support you to make decisions. Firstly, the people who are supporting you should always start by asking you what your thoughts are. It's important that your supporters listen to your point of view respectfully, even if they don't agree with what you're saying. There's a concept called the dignity of risk, which refers to the idea that we always accept some risk when we make decisions. We all make bad decisions sometimes, and often we learn a lot from those mistakes. Dignity of risk reminds us that disabled people have as much right as anyone else to think about how much risk you want to take on and to make bad decisions. And just because your support people don't necessarily agree with what you want to do, that doesn't mean they should automatically overrule your decision. You should also get the opportunity to talk to your circle of support. So your circle of support is the people in your life who you trust to help you make decisions. You can decide who you want to be in your circle of support. For example, you might want to talk to family members, friends, a counsellor or support worker. You might want to write a list of the names and contact details of the people in your circle of support so that when you do have to make a decision, you can easily get in touch with the people you want to talk to. It's also important to gather information to help you make a decision. For example, if you're deciding whether to take a certain medicine, you might want information about what the medicine is meant to help with, how long you'll need to take the medicine for, what the side effects might be, and what you should do if you experience any of those side effects. Your doctor might be able to give you that information, or you might be able to find it on the internet. You have the right to receive information in a format that is accessible for you. So if you need written documents in easy read, or if you need a sign language interpreter to be present for appointments, you should ask for these things. And finally, it's important that your supporters ensure you have enough time to make your decision. Processing all the information and thinking about what you want to do takes time, and it's important that the people supporting you don't rush you. So now we're going to look at an example of how supported decision-making might work. So here's the example. Jake and his mum Mary went to his routine dental appointment at the local hospital. When they met the dentist, she asked Mary questions. She asked Mary to sign a surgery consent form on her son's behalf for his upcoming dental surgery. Mary said that Jake needed to make the decision and sign the form. The dentist insisted that the form required a signature that day so the surgery could be booked. Mary said that she and Jake needed time to discuss the form and the reason for signing it. Mary suggested that while the dentist continued her appointments, Jake and Mary could discuss the form while still at the hospital, and then they could come back with a decision. The dentist agreed. This gave Jake and Mary the time to discuss the surgery and the information on the form. Mary asked Jake if he would like to speak to his stepbrother Rob to talk about it some more. Jake agreed, and Mary used her mobile phone to call Rob. Jake had a further discussion with Jake about the surgery and the consequences of having it and not having it. Jake was also reminded about the last time he had dental surgery. After talking to Rob, Jake said, "I say yes." When Jake's dental appointment resumed, Mary said that Jake was ready to sign the form. The dentist asked Jake to confirm. Jake repeated, "I say yes." So, first question to answer here, what elements of supported decision-making do we see happening in this example? Well, we clearly see the circle of support happening. So Mary talks to Jake about the information on the form, and then Mary also puts Jake in touch with Rob, another person in his circle of support that can help support Jake to make this decision. And we also see the importance of taking time to make decisions. So Mary stood up for Jake's right to take the time to make the decision for himself, and she found a way for them to be able to take that time, even though the form had to be signed that day. And so how did Mary advocate for Jake's right to practice supported decision-making? Well, she clearly advocated, she insisted that it needed to be Jake who made this decision for himself, and then she worked out a way to support Jake to make that decision for himself, including by, for example, suggesting that they stay at the hospital to talk about it and sign the form that day, but not signing the form immediately like the dentist wanted. So now we've covered supported decision making, we're going to move on to talking about this act I've mentioned a few times before, the Protection of Personal and Property Rights Act 1988. So this is used when more than just supported decision making is necessary. And because protection of personal and property rights is a bit of a mouthful, it's often called the PPPR Act for short. So you can see this came into force in 1988, and when this law came into force, deinstitutionalisation was happening. So New Zealand was moving towards supporting disabled people to live in the community rather than having disabled people live in institutions. This means that it doesn't always fit especially well within the modern context. In particular, the PPPR Act doesn't always align well with the focus on supported decision-making that our current disability strategy supports. And in fact, the Law Commission is currently reviewing the PPPR Act to see whether changes need to be made to make it fit the modern context better. Nevertheless, the PPPR Act does currently remain in force. So the PPPR Act says 4 key things about a person's decision-making ability. So it presumes that everyone has capacity, and it says that everyone has the right to make decisions about their lives. And this is unless or until it is proven that the person does not have capacity. And it underlines the fact that people should make decisions for themselves whenever possible. So, as you can see from this list, a key concept within the law is capacity. So, what is that? Well, according to the law, capacity is the ability to make decisions, to understand the consequences of a decision, and to communicate a decision. And capacity is normally determined by a medical assessment. Now, who carries out this medical assessment will depend on what decision needs to be made and the circumstances. For example, how urgent or serious the decision is. In emergency situations, it might be the attending doctor who assesses capacity. In other situations, it might be your GP, a specialist, or even a multidisciplinary team. So, when deciding whether the PPPR Act needs to be used to empower others to make decisions for you, the first question anyone will ask is whether you're over 18. This is because until you turn 18, your parents are your legal guardians and can make decisions for you. However, once you're over 18, the next thing to consider is whether you have the capacity to make decisions. If you're assessed as having the legal capacity to make decisions, you can set up an enduring power of attorney or EPA. And if you're assessed as not having the legal capacity to make decisions, someone will need to apply to the family court for orders that empower them to make decisions on your behalf. So we'll go through each of these options in turn, looking at enduring powers of attorney first. So an enduring power of attorney is a document that you create when you do have capacity, and it enables you to decide who you want to make decisions for you if you do lose capacity. Now, it's a really good idea for everyone to have an enduring power of attorney in place because you never know when you might lose capacity. For example, if you had a serious accident and were in a coma, having an EPA in place would mean someone you had chosen could make decisions on your behalf. And this gives you more legal protection than simply relying on someone being an emergency contact or your next of kin. So when you create an EPA, you are known as the donor, and the person you give the decision-making power to is the attorney. Now, just keep in mind, this doesn't mean attorney in the same way you might see on an American TV show where it's used interchangeably with lawyer. In New Zealand, attorney refers to the person who has been given a certain decision-making power legally. So you can use an EPA to authorize another person to make decisions about your personal care and welfare and about your property. You might want the same person to be your attorney for both personal care and welfare and property, or you might want to have different people in each of those roles. That's up to you. So your attorney for personal care and welfare will only be able to make decisions for you if you lose capacity. They'll make decisions about things like where you will live, who will look after you, and what medical treatment you will receive. And you can decide what types of decisions you want to allow your attorney to make. You might decide to grant them general power to make all decisions about your care and welfare, or you might only empower them to make specific decisions. With your attorney for property, you can decide whether they will only gain power to make decisions for you if you lose capacity, or if you want them to give them the power to make decisions for you while you still have capacity. This means that if you want someone to help you manage your money and property while you still have capacity, you can give them, you can set up an enduring power of attorney to give them the legal power to do so. And just like with the personal care and welfare attorney, you can decide what powers you want to give your attorney for property. For example, you might want to only give them power over a specific bank account, or you might want to give them the general power to manage all of your financial affairs. So, who should you choose to be your attorney? Well, there's a couple of things to keep in mind when you're choosing who you want to be your attorney. Firstly, the person does need to be over 20 years old and they need to be of sound mind. Obviously, you should choose someone who you trust to have your best interests at heart. You should choose someone who has the skills necessary for managing your affairs. And obviously, you need to talk to the person and they need to agree to be your attorney. Now, the enduring power of attorney needs to be signed by you, the donor, and by your attorney, and your signatures need to be witnessed by either a lawyer, a legal executive, or an authorised employee of a trustee corporation. This means you'll need to see a lawyer or a trustee company to help you set up your EPA, and I'll give you the details of some organisations that can help you set up your EPA at the end of this presentation. So, what happens if you don't have the capacity to make an EPA, or if you lose capacity and you don't have an EPA in place? In those situations, someone will need to apply to the family court to be granted the power to make decisions on your behalf. Now, like with an EPA, the court can grant someone the power to make decisions in relation to your personal care and welfare, or in relation to your property, or both. So in terms of personal care and welfare, the court can make specific orders, such as an order that you will live in a specific place or receive specific medical treatment, or the court can decide to appoint you a welfare guardian who can make decisions about your personal care and welfare. The court should only appoint you a welfare guardian if they're satisfied that you completely lack the capacity to make or communicate decisions related to your personal care and welfare, and that appointing a welfare guardian is the only satisfactory way to ensure that appropriate decisions are made for you. And if the court decides to appoint you a welfare guardian, they need to try to find out from you who you would like your welfare guardian to be if they can. The court will review the order appointing your welfare guardian every 3 years. This helps to ensure that your rights are being upheld and that you don't have a welfare guardian if you no longer need one. So, your welfare guardian must always protect your welfare and best interests, and they must encourage and support you to make the decisions that you're able to make and to be a part of your community. And where possible, your welfare guardian must consult with you before they make decisions. And there are also certain decisions that a welfare guardian can't make. So your welfare guardian can't make decisions about you getting married, entering into a civil union, or getting divorced. They can't make decisions about your children being adopted. They can't refuse consent to standard or life-saving medical treatment, which means that they can't request a do not resuscitate order for you. They can't consent to you receiving electroconvulsive treatment or brain surgery that's meant to change your behaviour. They can't consent to medical experimentation unless it's intended to save your life or prevent serious damage to your health. And they can't consent to assisted dying. Now, when it comes to property, the court can decide either to appoint a property administrator or a property manager, and that will depend on how much property you have. So if you have less than $5,000 worth of assets, or you earn less than $20,000 per year, the court will appoint a property administrator. And if you earn more or you have assets worth more, the court will appoint a property manager. The main difference is that because property managers are responsible for more money, there are more requirements for them to report to the court on how they are managing your money, and then the public trust checks these reports. So the order from the court will explain exactly what your property administrator or manager is allowed to do. So it's important to read it to understand what they're allowed to do. But they're normally empowered to do things like manage your money and bank accounts, pay bills on your behalf, make sure your tax returns are filed with IRD if necessary, renting out a house or flat, or manage a business on your behalf. And like a welfare guardian, your property administrator or property manager must always act in your best interests. And there are also certain things that they can't do. So they can't be paid for their services unless the court has specifically authorised this, but they can have their expenses reimbursed from your money. They can't act in bad faith or without reasonable care. And if they want to buy or sell property that's worth more than $120,000 on your behalf, they have to specifically apply to the family court for permission to do that. Now, it's important to know that if you are not happy with the decisions that your welfare guardian, property administrator, or property manager is making for you, or if you think that they're doing something that they don't have the power to do, you have the right to speak to a lawyer. This is the sort of issue you can talk to Auckland Disability Law about. And if you need help calling Auckland Disability Law, you could try talking to one of the people in your circle of support to see if they will help you contact us. Also remember that even if you do have a welfare guardian, a property administrator, or a property manager, they should still support and encourage you to make decisions for yourself when you can. They shouldn't make every decision for you without considering your views. So this means that your welfare guardian, property administrator, or property manager should be practicing supported decision-making with you whenever possible. So here we've got a few contact details of useful organisations that you might want to contact for help. And this information is also on the handout that will be sent around to you. So firstly, our website, phone number, and email address are up there. On our website, aucklanddisabilitylaw.org.nz, we've got a section which has some resources about supported decision-making. So if you do need more information about supported decision-making, that's a good place to go. I've also put there the website for community law centres in Aotearoa. So there are 24 community law centres around the country, and most of these are location specific. So there's likely to be one in your local community. Some community law centres will be able to help you write an enduring power of attorney, but this varies from region to region. So you'll need to contact your local community law centre to find out if that's something they can help with, and you can find their contact details on that web link. Now, support from community law centres is free. I've also put there the link to the Law Society's Find a Lawyer page. So that is another place that you could find a lawyer to help you with setting up an EPA or with going through the process for getting orders under the PPPR Act at the family court. Those are likely to be lawyers that you would have to pay a fee for. I've also put there the website for the Personal Advocacy and Safeguarding Adults Trust. They have advocates who can help you stand up for your rights in the community. For example, your right to practice supported decision-making. So they're another good place to go if you have questions about any of this. And finally, I've put up there the link to the Public Trusts page on creating an enduring power of attorney, because they have a service where you can pay a small fee and they will help you set up your enduring power of attorney. So just to sum up, today we talked about what supported decision-making is and how to do supported decision-making. We then talked about what legal options are available if someone else needs the power to make decisions for you. So those options where you can make an enduring power of attorney if you have the capacity to make decisions and you want to appoint someone to make decisions for you when you lose capacity. Or if you don't have capacity to make decisions and you don't have an EPA in place, the family court can appoint someone to make decisions for you instead. However, even when someone else does have the legal power to make decisions for you, they should still support you to make decisions for yourself as much as possible. So supported decision-making is really at the centre of everything.